Good afternoon, and welcome to a national call to discuss protecting tenants at foreclosure. My name is Jeremy Bergstrom, and I am a senior staff attorney in the Housing Justice Unit at the Sargent Shriver National Center on Poverty Law. The Shriver Center is a law and policy center that provides national leadership in identifying, developing, and supporting innovative and collaborative approaches to achieve social and economic justice for low-income people. The purpose of today's call is to provide current information about the status and future prospects of the Federal Protecting Tenants at Foreclosure Act, and to share information about what some states have been doing to enact protections for tenants in foreclosed properties at the state level. Our hope here at the Shriver Center, at least, is that other states will follow suit, and we want to both encourage and support you in that endeavor. I'm very fortunate to be joined by an esteemed group of panelists today who will be introducing themselves momentarily. First, a few technical pointers. If you have questions or problems with your connection, you may contact Joelle here at the Shriver Center. Her phone number appears on your screen. If you are calling in with your phone, please enter your audio code now. You should see this code on the control panel on the GoToWeb control panel on your screen. It's the pound sign followed by 2 digits followed by another pound sign. This will allow us to activate your audio if you want to take part in the conversation. We have over 450 people registered for this call, so we'll obviously need to leave microphones muted until the scheduled opportunities for questions or comments. There will be opportunities to ask questions and participate in the discussion at a few points in this call. First, panelists will discuss the current status of the federal PTFA and the results of efforts to extend it last year, as well as discuss current efforts to reintroduce a federal bill. We will then have the first opportunity for your participation. Next, 3 panelists will talk about successful efforts to pass protections in their states, namely California, Maryland, and Illinois. We'll then take questions and comments about state-level initiatives. Finally, we will open the discussion to general questions and comments. At that time, we welcome you to brainstorm strategies for advocates in states where there currently are no state-level PTFA protections, as well as discuss anything else that you have on your minds. Because of the large number of participants, to ask a question or comment, please type it into the message field in the webinar control dialog. You'll want to toggle your message so that it's sent to the questions recipient box. You should see what I mean when you toggle that field there. We have a team of people here at the Shriver Center who will identify questions and people who wish to make a comment. If I call on you, please be prepared to have your audio unmuted so that you can speak. You will be able to ask your own question. Again, you will need to have entered your audio code for us to do that. It may take a few seconds for us to find you on our list of participants to unmute you, so we will appreciate your patience. I will let you know when your mic is live. Please note that this webinar is being recorded and it will be available for viewing on the Illinois Legal Aid online and Shriver Center websites. Your active participation indicates your express consent to this recording and redistribution. Finally, after the webinar after the webinar completes, you will be prompted to take a short survey to let us know how we're doing. With all that in mind, I'd like to turn to my fellow panelists to ask them to please introduce themselves in the order of their presentations. So, Tristia, if you could please let us know who you are.
Hi, my name is Tristia Bauman, and I'm a senior attorney at the National Law Center on Homelessness and Poverty.
Linda.
Hi, my name is Linda Couch. I'm the Vice President for Policy at the National Low Income Housing Coalition.
Kent.
Hi, I'm Kent Chen at the National Housing Law Project. I'm a staff attorney at NHLP.
And Matt.
My name is Matt Hill. I'm an attorney at the Public Justice Center in Baltimore, Maryland.
All right, thank you. And Tristia is going to begin the discussion by telling us about the current status and last year's efforts to extend the PTFA. Tristia.
Thank you, Jeremy. Well, as everyone on the call knows, the Protecting Tenants at Foreclosure Act has now expired. It expired at the end of last year. I will talk about some of the events leading up to that expiration, but it may be helpful to give some context. The Protecting Tenants at Foreclosure Act was an important federal response to the national foreclosure crisis. And this response was necessary not only because of the magnitude of the crisis and its national scope, but because in 2009, when the PTFA, or Protecting Tenants at Foreclosure Act, was enacted, there was a shocking lack of protections at the state and local levels afforded to renters in foreclosed properties. Leading up to the initial passage of the PTFA, a 50-state review of renters' rights protections was done by the National Law Center and the National Low-Income Housing Coalition. And that survey revealed that in many states, responsible renters who had always paid their rent on time, abided by their lease terms, and perhaps had no clue that their homes were in jeopardy could be legally evicted upon very little notice. And also, many states allowed for the legal termination of a lease agreement just based on the foreclosure itself. Since the PTFA's enactment, several states have passed new protections for renters, some matching or even exceeding the protections offered under the PTFA, which you'll hear more about later in the presentation. But still, advocates on the Hill argued that the PTFA, a uniform set of protections available to renters from coast to coast, was still necessary. Unfortunately, Congress did not agree. The PTFA was passed in 2009 as part of the Helping Families Save Their Homes Act, and then clarified and extended in the 2010 Dodd-Frank Wall Street Reform and Consumer Protection Act. It was only in effect until December 31st, 2014, and two bills that were introduced in the last Congress provided for permanence, PTFA permanence. There were arguments to extend the federal legislation and also to add in a private right of action, but those bills were never able to make it through the Congress, and ultimately the PTFA expired. The reasons for that are many. Some of it is related to the composition of the Congress. When the PTFA was passed, Democrats were in full control of the House and Senate. In this last Congress, that was no longer the case, and there was no clear Republican support for PTFA permanence or extension, and Republicans controlled the House. In order for the PTFA bills to be successful, you would need at least acquiescence from House Republicans, if not outright support, and House Republicans expressed some concerns about extending the PTFA. Those concerns boil down essentially to two separate things. One, landlord-tenant issues are normally a matter of state law, and the thought was among House Republicans that the emergent circumstances surrounding the PTFA's initial passage no longer existed. In other words, they wondered why the feds would interfere, particularly since the worst of the foreclosure crisis had passed. Also, there were concerns related to amending Dodd-Frank, and those concerns were unrelated entirely to the substance of the PTFA, but instead were related to the politics of amending Dodd-Frank at all. Beyond these concerns, there was not strong opposition to extending the PTFA. The banks didn't really lobby on it, and it's unclear how much of that was related to the lack of momentum on the Hill to pass a PTFA extension bill, and how much was due to the PTFA proving to be a workable system for financial institutions. There is still interest in federal legislation that would protect renters in foreclosed properties, but that would of course need to be reintroduced in the current Congress or in a future Congress. And I'll turn it over now to Linda Couch at the National Low-Income Housing Coalition to talk about that. And what you see right now on the screen is my contact information, which will be available, as Jeremy said, on the Shriver website. I would encourage anyone to contact me, particularly as state efforts to pass PTFA-like protections are underway, as the Law Center has a very keen interest in being supportive of those efforts. So please feel free to contact me. And with that, I'll turn it over to Linda.
Thanks, Tristia. So as Tristia just explained, in the last Congress we did have a great Senate bill and a great House bill introduced by Senator Blumenthal from Connecticut and Representative Ellison from Minnesota, respectively. And I'll just add to what Tristia said by saying that the Republicans hate Dodd-Frank just about as much as they hate the Affordable Care Act, and extending anything that had any connection whatsoever to Dodd-Frank was completely against, everything in their DNA. And so that really did prove to be a big hurdle. But getting to this Congress, and the next slide is, we do expect that Senator Blumenthal and Representative Ellison will continue to champion the Protecting Tenants at Foreclosure Act. They have already been meeting. In fact, they've met, both offices have met together, and there's been a lot of email traffic and a lot of phone calls already this year. They're committed to working together to get PTFA extended somehow in this Congress. The possibilities for new PTFA bills would be just a straight reintroduction of what was introduced last year, and that, of course, would be making the PTFA permanent, including a private right of action. Another option, and this seems to be the more likely because of the Dodd-Frank issue, is an introduction of, well, not because of just the Dodd-Frank issue, but just to sort of simplify everything, is to introduce a clean bill, and that means no private right of action and not a permanent provision, but maybe a one-year PTFA extension. And it would be a one-year extension because the goal through this course would be to have it included in the annual appropriations bill for housing. And therefore, it'd be really important that our champions were working closely with appropriators, because we think that this avenue is more likely to be amenable to senators versus House members. We do think that the key Senate appropriators, Senator Collins, who's the chair of the Housing Subcommittee in the House and the Senate, and Senator Jack Reed, who is the ranking member, the lead Democrat on the Housing Appropriations Subcommittee in the Senate, will be really important moving forward. But if you are in Minnesota, if you're in Connecticut, it's really important that you let Representative Ellison and Senator Blumenthal know, if you can, that we thank them for their work on PTFA. They are paying really close attention to any information we get. We meaning all the groups on this call, about what the impact is on tenants of not having PTFA protections any longer. And then finally, I'll end by saying that we have learned from Fannie Mae and Freddie Mac that they do intend to continue to impose PTFA-like protections in their stock going forward. We have, they haven't put out an official policy saying that, but that's what they've told Hill offices, and it's what they've told members of the media. So we're hopeful that that will stick. And with that, I will turn it over.
Thanks, Linda. One question that came to my mind: you mentioned that it's important for people in those states to take some action and reach out to their legislators. Just gauging by the interest in this call, clearly I think this is something that advocates are concerned about nationwide. Is there an opportunity now for advocates to express some support for a reintroduction of the PTFA? And along those lines, would there be a way for people to follow, either on your website or through some newsletter or blog or something, opportunities for them to become involved in the advocacy?
Well, absolutely. So now is a great time to encourage Senator Blumenthal and Representative Ellison to introduce PTFA bills. And what they, I think, really want to hear about are the problems with not doing so, and why is it important that PTFA be extended and be put back in force. The Low Income Housing Coalition, we produce a weekly newsletter called Memo to Members that you can follow on our website, and we'll have the latest in there. Certainly, if there's any kind of a bill, we will rally our network to increase co-sponsors of that bill. So on our homepage of our website, there's there's a place where you can put in your email to get our action alerts. You don't have to be a member to do that. and we can certainly keep you in the loop that way. But this is I think that this in some ways should be a really easy ask, and we're hoping that we can help Senator Blumenthal and Representative Ellison be really successful in this effort.
That's great. Thank you. So if anybody has any questions, please feel free to go ahead and type them into the chat dialog box now for Linda and Tristia. Don't see any currently pending, but we will definitely make, they will be available to answer your questions at the end of this call as well. It will be helpful to our staff on our end if people type out their questions as soon as possible so that we can receive them and sort out getting you unmuted so that you can engage in a conversation with the advocates, with the panelists. So thank you again to Linda and Tristia. I'd like to turn this over to Kent Chen, who is going to talk about the research that he's done to learn what's been happening at the states.
Thanks, Jeremy. So here you see on your screen a chart of some state law protections for tenants. So as you can see, about 10 states still have state law protections that's mostly equivalent to the PTFA, or they have stronger laws such as DC and Massachusetts and Jersey and Rhode Island that have just cause for protection, which means that foreclosure is just not a reason to evict tenants after foreclosure. But that said, with the exception of Nevada and Washington, which also have 60-day notice laws, most of the country now don't have any specific protections for tenants after foreclosure. So they can now, after expiration of the PTFA, be evicted with very little notice at all. So it makes it even more important to enact state law protections in these states to, now that PTFA has expired, to give tenants at least some notice and some time to move, and as well as the argument that can be made for a lot of local jurisdictions is that tenant-occupied properties protect neighborhoods from vacancy and vandalism and help to preserve property values in neighborhoods. And that has definitely been an argument that we made in several California jurisdictions, and also when we were doing our state bill in California to enact protections for tenants after foreclosure.
Thanks, Ken. You have a question. Somebody has asked, what do you mean by just cause? If you could just briefly discuss that.
Yeah, just cause just means that in some jurisdictions, a lot of times they're rent control jurisdictions in the past, but what it means is that a tenant, landlord cannot terminate a tenancy without a good reason. And usually expiration of a lease is by itself not even a good reason to terminate a tenancy. So those laws were enacted in rent control jurisdictions to keep the rent control aspect of the law workable, because if the landlord can terminate a tenancy for no reason in the lease, and the rent control protections the tenants will lose their rent control protections. But with the foreclosure crisis, a number of states and local jurisdictions have extended those protections to tenants after foreclosure on the basis that the tenants have really done nothing wrong, and they shouldn't have to be forced to leave their homes just because of foreclosure. Instead, there must be something that they did wrong, like not paying their rent or violating their lease, for the bank or the purchaser of foreclosure sale to evict them and terminate the tenancy.
Great, thanks. Kent, before you go on to tell us about what you did in California, I'd like to back up for just a moment for a question for Tristia and Linda. Something that we panelists discussed amongst ourselves before the call. Maureen Gottlieb, we're going to unmute you now. You've been unmuted, so you can go ahead and pose your question to Linda and Tristia about Fannie and Freddie. Okay. Well, Maureen Gottlieb, I'll go ahead and ask your question for you. You pointed out that several states, that in several cases, Fannie and Freddie have not been choosing to follow PTFA, and at most they'll give some notice, but they're, in other cases, treating tenants as trespassers. Tristia and Linda, is there anything that you can add as far as the level of what we can expect from Fannie and Freddie?
This is Tristia. The Law Center has encountered over the lifespan of the PTFA many reports of Fannie Mae and agents of Fannie Mae violating PTFA protections. It's encouraging on the one hand that both Fannie and Freddie intend to continue to act as though the federal law had been extended and maintain their practices. What that looks like on the ground in reality moving forward, I'd have to imagine is going to be more of the same, which we know to be problematic. I'm not sure how helpful an answer that is, but I think that is the actual answer.
Fair enough. Thanks for your insight there. Kent, somebody has asked, a couple of people have asked if they contact you, are you willing to share information about where people can find their local state protections? In other words, if you have a list of statute numbers or something like that?
Yeah, I mean, actually, we have a website. NHLP maintains a website, which, you know, I'm not sure if it's on. It's on the presentation materials, but if you go to NHLP.org, there's a section on state and local protections for tenants after foreclosure. So if you just search for that, we have a website with statutory citations to all these different laws.
Great, thanks. And Noel Morgan pointed out that he has some insight into what's going on in Ohio. Can people also contact you if they want to update you on nuances in their states?
Absolutely. I mean, if you see any, if you have any updates, or if you have any, if you see an error in how I classify a law or in the description on the website, please let me know. I'm not an expert on all 50 states' landlord-tenant laws, so it's not always clear from statutes how they apply to tenants after foreclosure. So if you got any updates or any specific information about your state, please feel free to contact me. I think my information is going to be at the end of the presentation.
That's great. And if you'll go ahead and tell us about what happened in California, we'll appreciate hearing from you on that.
Sure. So in California, we've been really dealing with the foreclosure crisis for a long time, partly because the foreclosure crisis simply hit California really hard. California is one of the hardest hit states in the foreclosure crisis. But also, we have a fairly progressive legislature, so that really helps in passing protections for tenants. So I'm going to start with 2010, but just keep in mind that we had bills even before then in 2008 to start protecting tenants in foreclosure situations. So one of the recent protections that we enacted was a protection to mass post-foreclosure eviction records. So that was a recognition of, again, that tenants are being evicted because of foreclosure out of no fault of their own. So their eviction record should not be marred by a foreclosure eviction. But unfortunately, many landlords don't distinguish between fault evictions and no fault evictions, such as foreclosure evictions, and treat every eviction as essentially a blanket denial. So we, Western Center and tenant advocates in California, went to the legislature to essentially get the courts to mask those records so that landlords don't have access to them, because tenants should not be, in that situation, should not be penalized for being involved in a post-foreclosure eviction. It also mandated a cover sheet because a lot that tell tenants in foreclosed properties that they have certain rights, such as the PTFA at that time, and also state law protections, because a lot of banks treat even owner-occupied properties as, even tenant-occupied properties as owner-occupied. So they don't recognize that tenants are there, and tenants who receive a 3-day notice addressed to owner don't know of their rights as tenants. So we required a cover sheet. We also passed a bill, and that bill actually got better as it went through legislature. It just started as a masking bill, and the cover sheet was added on later on. SB 120 with the utility shutoff protections. We had a shutoff protections for multifamily properties historically. That was enacted a long time ago, but the foreclosure crisis affected a lot of single-family properties where tenants' utilities were being shut off, so that we got a bill, SB 120, to extend those protections to single-family protections. The bill originally was actually a lot more ambitious. It would have also required the return of security deposit and also extended our anti-lockout protections to tenants after foreclosure. But because the PTFA sort of extended the tenancy protections after foreclosure, we dropped those provisions from the bill and just left the utility shutoff protections on the assumption that the federal law now gave the tenancy protections to tenants after foreclosure, and there's less need for state law protections on that regard. Next slide, please. The big bill that now provides the main protections for tenants in foreclosure was passed in 2012. So that was a very unique legislating environment, because that's also the bill was introduced at the same time that our homeowner bill of rights to protect homeowners in foreclosure was introduced and sponsored. And that bill was sponsored by the California Attorney General, Kamala Harris. And this bill for tenants was also sponsored by the AG's office. That creates a very different dynamic in the state legislature, because the Attorney General's office was behind the homeowner bill and the tenant bill. And also, it in some ways diverted a lot of attention from the tenant bill to the homeowner bill. So what it did is it provides a 90-day notice requirement for all tenants. So if you remember, the federal law impose some bona fide tenants requirements, such as you can't be related to the homeowner, and the rent must be substantially less than for market rent. But in practice, we encounter situations where the banks were unfairly denying people PTFA protections because they dispute whether the tenants were bona fide tenants or not. We wanted to sort of remove that dispute. So the bill was introduced to give a 90-day notice and lease protections for all tenants, regardless of whether they satisfy the bona fide tenancy requirements or not. The bill with the 90-day notice protection didn't really encounter a lot of opposition, but the lease protections did. People were objecting, bringing up scenarios of what if the tenant had a 2-year below market rent lease, and that's negotiated with a relative, things like that. So we try to amend the bill that to protect some kind of to provide some kind of less protections, but still objective standards, such as using the HUD small area FMR standard to determine whether the lease is the rent under the lease is fair market rent or not. But eventually, we simply just adopted the federal standard, but we did shift the burden of proof to the landlord, that the landlord has to prove that the lease did not satisfy those requirements, the bona fide tenancy requirements. And we also required landlords to provide the foreclosing lender to provide notice of tenants of these rights before the foreclosure sale, and that notice must be translated to the 6 most common languages in California. We got SB 1191, which is introduced in the same year to require landlords to disclose a pending foreclosure to prospective tenants. That's also a big problem when tenants enter into leases without knowing that the property is undergoing foreclosure. And this is actually one of the bills, again, where it got better through the legislative process because of strong tenant advocacy. In the beginning, the bill was only required the landlord to disclose at the very end of the foreclosure process, after the sale has been noticed. And we were able to extend that period to when the foreclosure, to require disclosure once the foreclosure process has started. And we also got a provision there that the tenant can simply just deduct 1 month's rent from their rental obligations instead of requiring them to file a lawsuit against a former landlord to recover any damages. And we also introduced AB 1953, which actually we copied this idea from Maryland and Illinois. Thank you, those two states, which we would require the purchaser of a foreclosure sale to tell tenants when to pay rent and who to pay rent to. And this is particularly important in California's rent control jurisdictions, where the tenancy is really, really important to keep the home affordable to low-income tenants. And the law will now prohibit evictions for non-payment rent when the bank fails to provide notice to tenants of the transfer ownership and where to pay rent. So this bill fairly moved through the legislative process, fairly unchanged, but we did have to add a provision that the rent is still owed. The landlord can't evict for non-payment of that rent, but can still collect that back rent from a separate small claims action. Okay, thanks, Jeremy.
Great, thanks. So appreciate that, Ken. Just for the participants' information, we'll take questions for all of the state panelists after each state is presented. So we're going to hear from Matt Hill about Maryland, and then I will talk about Illinois, and then we'll take questions and answers. Matt.
Yes, hi. So very similar to California in many ways. This was in 2010. We enacted revisions to Maryland law that would pretty much incorporate and clarify the PTFA in Maryland law. Similar to California as well, we required notice prior to the sale to all occupants, informing of likely rights under the PTFA for any tenants. We clarified that you have to actually have legal title before the purchaser can give the notice to vacate. We also clarified certain things about the notice, that it has to be by first class mail, certified mail. It has to state the date that it's given, the date that it's effective, and whether or not it's terminating a term lease, a month-to-month lease, or because of a sale to the owner occupant. And there is no sunset date in that provision. So that was the big incorporation and kind of clarification that we were able to get done. Next slide, please. Reflecting on why we were able to get that done, certainly one reason that is no longer, unfortunately, relevant is that we were able to say that we needed to get state law into alignment with federal law to reduce the confusion that exists and promote broader compliance with the federal law. I think that the stories, just the individual client stories, are still, the most compelling sources that we have in our advocacy. I remember we were able to get one very cute old couple onto the front page of the Baltimore Sun with giant boxes packed around them because they were confused about their rights. They hadn't been given the proper notice under the PTFA, and that was a real boon to our advocacy effort. As Kent also said, another powerful argument that's still very relevant is keeping foreclosed properties occupied instead of vacant and a blight on the community. And in that respect, we were able to align with community development corporations and other community-based associations to get them to take a position on the bill and really advocate for it. I think that, back in 2010, as well as today still, at least in Maryland, I think in a lot of states, there are very tight fiscal restraints on the state's budget. Legislators don't have a lot of fiscal items with a fiscal note that they can bring home, and so banks are still unpopular to a certain degree, and this is something that a legislator can say, well, I'm sticking up for the people through this kind of legislation, and again, I think that's still a good rationale that you can use to help promote this kind of law. Next slide, please. So similar to, again, and I guess we don't need to belabor this since Kent already went over this in California, we were having a problem with purchasers, primarily banks, saying, okay, well, you can be a bona fide tenant, but you have to pay us the rent for the past 4 months in which your landlord had just disappeared. Nobody was taking care of the property. You didn't know what was going on. But if you want to stay, you got to pay us those 4 months rent. And we thought that was a little unfair, and we were able to convince enough legislators on just a basic fairness level that if a purchaser wants to collect rent, that's fine. They just have to give a notice to the tenant and tell the tenant, where to send the rent and who's in charge of property maintenance. And in Maryland, we were able to do that with the provision that the purchaser waives the right to any rent that may have accrued prior to giving of that notice. So those are the main provisions we were able to do in Maryland. If I could get in my time machine and go back and do it over, I probably would have included a couple other things that we still see, because these have been pretty effective in getting broader compliance, getting tenants notice, getting them some time to get their belongings together and to make a smooth transition. However, we still see some banks, purchasers, their attorneys, who try to give what we call a one-size-fits-all notice. So in other words, they don't try to figure out who lives in the property first and what kind of tenancy they have. Instead, they just send a notice that says, well, if you're a tenant, then you may have certain rights, and if you're a month-to-month tenant, then you have to be out in 90 days, and if you have a longer lease, then you may be able to stay to the end of the lease, but send us all your information, and we'll make that determination later. And then, of course, the tenant sends them a bunch of information. They never hear back. Now, those have gotten a little bit better, and they're quite a bit clearer than they were when we first started, but we still see some firms who do that, even with the Maryland law and even with those provisions that tell the purchaser what exactly the notice should say. So if I could go back, I would try to legislate that the bank has to do a reasonable inquiry into the type of tenancy prior to giving the PTFA notice. I would also probably make clear that the purchaser is not allowed to ask the tenant for proof that all rent that may be due and owing under the lease is paid. I think that's already clear enough in the statutes, and whenever we have an individual case, we certainly win on those issues. But that doesn't prevent a number of purchasers and their attorneys from continuing to engage in that behavior. And we've struggled a little bit to find a systemic answer to some of those issues. But otherwise, that's been the Maryland initiative that we've been able to do. And again, it's been fairly successful in getting better compliance and getting folks a chance to gather their belongings and to make a smooth transition.
That's great. Thanks so much, Matt. Was there any talk about a private right of action going into your advocacy? There wasn't, and certainly that would have been useful to maybe address some of the systemic issues that I was just discussing. But we were walking a pretty tight line in a lot of this advocacy because we didn't have a whole lot of resources to put into this issue. And so we were trying to make sure that we got the most critical aspects of the issue addressed to our clients in terms of getting as much clarity in the bill as possible without provoking too much opposition. So it was our judgment at the time, and it was a quick judgment, that putting in a private right of action specifically would have possibly created a lot of opposition that we weren't necessarily resourced to deal with. We've talked about maybe filing something under our Consumer Protection Act, but there are all sorts of legal obstacles to doing that for private parties in Maryland. So that's why we're struggling with it. Certainly would have been nice to have, but the political realities were different. Sounds good. So here's Matt's contact information, and I assume, Matt, you'd be able to answer any questions about what you did if people have them specifically.
Yep.
And just to remind everybody, there are a few questions that are coming in, and we will get to those after I talk briefly about what we did here in Illinois. In 2013, the Shriver Center and others worked as a coalition to introduce Senate Bill 1602. We found a sponsor who had already been introducing and passing bills related to foreclosure, Senator Jacqueline Collins. As Kent mentioned, there had been an earlier bill that required purchasers to identify and then contact renters of foreclosed properties and notify them about, for example, their right to contact, or suggesting that they contact legal services and their right to have independent legal representation on their own. What we did in 2013 was to introduce a bill that would route all eviction cases involving foreclosure through the state forcible entry and detainer proceedings. Illinois is a judicial foreclosure state, and there are a couple different opportunities for financial institutions to seek, or I should say that the subsequent purchasers to seek possession of a foreclosed unit away from renters prior to the federal PTFA, and then of course before what we did in Illinois. So we wanted to make it clear that anytime a subsequent purchaser is seeking possession from a renter, that they have to go through an eviction case. And part of that was basically just for training. As you know, most renters are unrepresented, and so there was a desire to try to streamline the information that is available to pro bono renters and let them know what their rights are once their property has been foreclosed. And so that was easiest, we felt, to do through an eviction case where judges and courtrooms are already set up to deal primarily with pro bono defendants. That was something that ultimately passed. Our initial bill timed out, and so we had to get another bill later on in the session and pick it up. So what ultimately passed was Senate Bill 56, and that does indeed route all cases through eviction court. We had required explicitly any purchaser to assume any rent subsidy. That did not explicitly get put into the final bill, but it also, there was nothing bad that happened in that regard. We just heard from some of our community partners that it would be helpful to have that explicit language. So again, our initial bill was pretty aspirational. It was basically just going to build on the protections for renters and then essentially require 90 days notice at least across the board in recognition of all existing leases. That's not what we ended up with, as I'll explain, but one of the things that we wanted to do was to require the subsequent purchaser to notify the tenant how to pay rent, and then require that they could only demand rent accruing after the confirmation of sale to the subsequent purchaser. That was pretty bitterly opposed by the financial institutions. We consulted with advocates on the ground floor, and they said that even though financial institutions had the right to collect past due rent that accrued under the old owner, in most cases they were willing to forego it or they settled it away. However, there were a couple cases pending that that had not been the case, so unfortunately that's something that we were not able to accomplish, although we tried. Now the notice that goes to renters in those properties only says that they it requires notice on how to pay rent if applicable. We also wanted some explicit language that tenancies survive foreclosure because there had been some question about that. We felt as lawyers that it had been resolved through case law, but we wanted to make it clear. We didn't get that either. So again, we had been seeking 90 days notice to all post-foreclosure occupancies except for the mortgager initially, and we wanted all existing leases, no matter how long, whether written or oral, to survive. We ended up with something a little bit less than that. The purchaser may only terminate with 90 days notice at the end of the lease, but the financial institutions did want an exception for purchasers who would use the property as a primary residence, and in that case they still have to give 90 days notice. We also had introduced cash for keys regulations as part of our initial bill. That was done because when we went out and worked with the community, with the neighborhood associations, primarily here in Chicago, we learned a lot of stories. We heard a lot of stories about abuses of the cash for keys offers that were being made. Really some terrible stories about, for example, renters vacating properties and then the landlord had left a broken down car in the garage and the financial institutions were not honoring the cash for keys payment. It may not have been the institutions themselves, but it was their agents, and we were trying to address some of the abuses. That was ultimately a non-starter with the financial institutions, and what we did through our negotiations was essentially drop all of those cash for keys regulations that we had introduced that you see on your screen in return for ameliorating almost all of their opposition on the Protecting Tenants at Foreclosure components of the bill. So what we ended up with is a definition of PTFA that applies only to bona fide leases. As Kent mentioned, we had been hoping to avoid that here when we passed the Illinois version, but we were not able to get around it. The financial institutions, again, that was pretty much a non-starter with them. They wanted that bona fide lease definition built in. So here in Illinois, that definition is a lease other than for the mortgager, child, spouse, or parent, but we did get them to agree that that's a rebuttable presumption. So here in Chicago, there are a lot of cases, primarily of immigrant families where there are multiple generations living in the same unit, and in some cases really truly paying rent to each other. So here, somebody can go into court and say, I really do have a bona fide lease, I'm paying rent, even though I'm the parent or child of the owner, and still get the protections. It does have to be at an arm's length transaction, and there is the fair market rent component as well. Also, this is an area where there was a lot of fighting in the negotiations. It took a lot of time to hash some of these nuances out. It applies to leases that are entered into or renewed on or before the filing of the lis pendens. So in Illinois, when a foreclosure case is initiated, there's a lis pendens that's recorded. And our point as tenant advocates was that renters don't know that. They're not going to go research the deed in properties where they're looking to rent and find out whether there's been a lis pendens. But the financial institutions were insistent that they wanted some threshold about how far, what leases were going to be covered. Or it also applies to cases where there's been a lis pendens filed but before the judicial sale, and the lease term is for 1 year or less. So there are some nuances here in Illinois. A written lease that's for more than 1 year after the lis pendens but before the judicial sale is treated as 1 year. Oral leases that are entered into before the judicial sale are treated as month to month or up to a maximum of 1 year with evidence. And then after judicial sale but before confirmation of sale, they're treated as, leases are treated as a month to month. So if it applies, essentially then they get the 90 days notice. That's what this means. So if the lease is considered bona fide, then they cannot be terminated less than 90 days before expiration of the lease, or a minimum of 90 days if there's not that much left of the lease. And it gets even more nuanced. So we were dealing, I don't know if he's on the line, but we were dealing with a really intelligent representative of the Illinois Bankers Association, and several lawyers in the room, and I guess if I could redo it, I would like to have made it more simple. I think that it's going to be tricky eventually to train advocates on how to train renters to understand whether or not their lease is covered, and if so, what protections they have. So for example, there's this nuanced definition of residential real estate and foreclosure. So the protections apply only to properties that meet that definition, and you can see the definition here is kind of wordy. And ultimately, it takes some sitting down and thinking about it to understand what this means. And really, I think the financial institutions were trying to figure out a way to ensure that only properties where there's been a foreclosure filed and that's ongoing, only in those cases is the renter available to take advantage of the protections. So part of the reason that what we ended up with here in Illinois was so nuanced is that we really did encounter quite a bit of opposition, really at several different levels. The larger banks, Bank of America, Chase, Wells Fargo, they all sent executives out to meet with us. They threatened to flood the State House with lobbyists. At one point during the negotiation, one of them said, I'm an unmute away from unleashing 30 lobbyists today. And at a couple of points, people were about to walk out of the room. So we had gauged amongst trusted legislators that we, even though there was some momentum for what was going on, and we still were dealing with a clear foreclosure crisis in Illinois in 2013, it would have been safer to have negotiated a final bill, and that was our sponsor's preference, and so we honored that. And so we had to ameliorate opposition from those larger financial institutions, and then a second group in Illinois, a powerful group of community banks, and then a third group of credit unions. And they each had lobbyists, they each had lawyers, and so it took multiple rounds of multiple negotiations with each of those, and in some cases keeping those conversations confidential from each other until there was some amount of, dare I say, playing off of each other in those negotiations because of some local state politics amongst those financial institution interest groups, if you will. So it was pretty complicated, and I think we're all glad that we have these protections in place now here in Illinois, even though what it's now turning into is another round of outreach to the advocates and to renters to teach them what this all means. So let's take a few questions here, and then Tristia wants to tell you something about reaching out to her. Let's see. Give me just a moment. We're going to unmute Bronson Stevens. Bronson, you're unmuted now. You had a question about PTFA and the application in certain circumstances.
Yeah. So we were facing a number of city tax evictions where the city had foreclosed on the properties for unpaid taxes, but most of the properties had tenants living in them. They were serving with 10-day notices that actually were for squatters, so there were defenses on that, but we were trying to push that the PTFA applied even though it didn't specify tax foreclosure or mortgage foreclosure. Luckily, we didn't have to litigate on that. The city that we were dealing with eventually conceded that point, but that process started in October, and now the PTFA is gone. New York has a specific, it's a broader than PTFA protection for mortgage foreclosures, but the real property law seems to indicate that under a tax foreclosure, the only protection is a 10-day notice from the purchaser. And I was just wondering if anyone else had run into protections for tax foreclosed tenants under either the PTFA or New York state law.
That's a good question. If a New York advocate's on the line that has an answer, feel free to type it in and we'll try to get an answer back to you, Mr. Stevens. I can say in Illinois that the definitions of the protections are such that it would apply to any foreclosure, regardless of the triggering mechanism, if you will. Kent or Matt, do you have any thoughts from your states?
Go ahead, Kent.
This is Kent. I don't remember exactly what the precise language of our state law was. But imagine, I mean, probably does, but I don't remember. And I think the argument under the federal law is very clear that it just applies to any foreclosure on residential real property. So the federal law, when it was still in effect, would have applied.
Yeah, and unfortunately, Maryland, the provisional law we incorporated did not specifically discuss tax sale foreclosures, so I think there's a pretty good argument that these protections do not apply in tax sale foreclosures in Maryland anymore.
Okay, and another question from Joe Mascoviak regarding the determination of leases, types of leases by the subsequent purchaser. Joe, you should be unmuted now if you're still on the line.
I am still on the line. I think this was for Matt in the Maryland experience. If I remember correctly, Matt, you said that they had to give a different notice depending on what kind of tenancy was there. I'm just curious as to how lenders determine that, because our experience here in Ohio, and I'm not taking lenders at their word, but they, of course, didn't even know there were tenants there when saying they didn't give PTFA notices, much less what kind of tenancy was there.
Yes, I mean, so our position is that the purchaser has an obligation under the Maryland rules. The way they're worded actually requires a reasonable inquiry into the occupancy status of the property, whether there's a tenant there, and to give the appropriate notice under the statute that I cited in the PowerPoint. So that's a Maryland-specific rule that requires that reasonable inquiry prior to the eviction. Now, as I said, we don't always see compliance with that provision. We do see banks who try to give a one-size-fits-all notice without having done a reasonable inquiry, and we then argue that those are misleading and confusing and ineffective, and we normally win on that issue. But it's still a problem.
Great, thanks. And so just entertaining general questions and comments now. Madeline Howard, you had a comment and a suggestion about a strategy that could be taken. Madeline, you're unmuted.
Yeah, I just wanted to comment that the advocates have been discussing the lack of private right of action in some of the state protections, and I think that there's an argument to be made that in state court, you can apply the same logic that the court applied in the Natiti versus Deutsche Bank, which interpreted the PTFA, and argue that even if there isn't a private right of action in the state statute, that an advocate can still bring like a wrongful eviction or another tort claim to enforce the state law protections for tenants in foreclosed property. So even if politically you can't get in that private right of action, you can still bring an affirmative claim based on your state law protections.
Great point. I appreciate you mentioning that. And I wonder if, Kent, if this might be an opportunity for you to jump in and tell us a little bit about whether you have any insight about what happens in cases where there is no state-level protection. What happens to cases where there's a lease in existence last year and they're just seeking foreclosure this year? Either they've served the notice last year, or are there different circumstances that might apply different levels of protection?
Yeah, I mean, I think there's a certain number of scenarios here. I mean, one scenario is simply a month-to-month tenant when the foreclosure happened last year, but the notice was served last year, then but expired this year. I mean, I think in that situation it's fairly clear to argue that the PTFA applied when you are providing a notice in 2014. It gets a little bit tougher when you're talking about a foreclosure in 2014 and a notice that was given, a new notice provided in 2015, and whether the PTFA still requires the eviction notice served in 2015 to be 90 days. I think that's a much harder argument to make, because the only relevant event that happened in 2014 is a foreclosure, but the notice itself was not given until 2015. The lease situation, there's probably a couple of scenarios there too. One is that the lease was the foreclosure happened in 2014, and then the lease expired in 2015. I think some banks might argue that the PTFA, when the PTFA expires, they can simply the PTFA protection simply drop out. I think the counter argument to that is to look at how the PTFA operates, and especially the cases interpret how the PTFA interacts with state law. Is that the state law operates at the point of foreclosure, in that leases and tenancies are terminated at foreclosure, and the only thing that PTFA does is at the time of the foreclosure, by preempting state law at that point of foreclosure, and basically simply transferring that lease at that point of foreclosure to the subsequent purchaser, as evidenced in the MIC and the TV reasoning in those cases. And because of that, because of PTF's operation of foreclosure, that it established that lease relationship between purchaser and a tenant, and the expiration doesn't do anything at the end of 2014, doesn't do anything to change that relationship, and that lease relationship continues after the expiration of the PTFA. I mean, I don't know of any cases on this, but that would be how I would approach those scenarios.
Thanks for that great analysis and for that expert advice. We'll certainly be watching for cases, and in the meantime, I know at the Shriver Center we encourage other states to not wait and to go forward with their own initiatives, and we stand ready to further answer questions you have or assist you in your endeavors, and I assume that's the case of the other panelists as well. Tristia, as we're at the end of the session, you had a request of those on the line. Go ahead.
That's right. I wanted to, again, reiterate that the National Law Center on Homelessness and Poverty, located in Washington, D.C., is very interested, for a variety of reasons, in being supportive of efforts at the state level to enact additional renters' rights protections. Of course, our interest includes PTFA-like protections, but any protections that get at the heart of a right to housing are of interest to us. So I'd encourage everyone on the line who is aware of efforts in their state to please reach out to us and see what resources we might have and discuss how we might be helpful to that. Also, I wanted to just preview a renters' rights violations database that the Law Center will be launching in fairly short order. The idea there is to collect information to help further some of the state-level efforts, but also to collect information that may be helpful to efforts on Capitol Hill here in Washington to re-implement a federal law protection for renters and foreclosed properties. So be on the lookout for that.
We will, and thank you to the work that you and Linda are doing in Washington. Please keep the rest of us informed of your efforts and what we can do west of you to encourage the momentum is to reintroduce these very important protections. I think, again, the interest in this call should let everybody know that there's definitely a need for these protections, and we'll hope that they're reintroduced. So thank you so much to my fellow panelists today. Certainly appreciate the conversation, and your contact information is listed on the screen now, so I hope you'll be ready to receive other questions. I'm sorry we weren't able to answer everybody's question today, but please keep them coming after the session. Be aware that this will again be presented on our Shriver Center povertylaw.org website pretty quickly after this call, as well as on Illinois Legal Aid online.org. And once we sign off, you'll receive a brief survey, and feel free to let us know what you thought about today's session. Thank you, everybody, and have a good rest of the afternoon.